For example, you may have created a database over several years that you regarded as your intellectual property that has useful information to you, and you may have added to that list over time. So you had a person's name, their ID number, their address, their cell phone number. Then you perhaps had an alternative contact number, a contact in case of emergency, and you kind of built out on what that information is. So the question is now, what information do I really need in respect to that person? If it's just to send them a newsletter, for example, perhaps all I need is their name and their email address. So you can automate and it's Dear Graeme, and they get their letter. Then it's not necessary to have all this other information, because sitting on that information is potentially risky to you, because if it was hacked or became publicly available, you could be in breach of POPI as a result of that. So understanding what you're holding, I think, is really important. I think one of the things also to be mindful of in regard to direct marketing, mail outs, that kind of stuff as well, is prior to POPI coming into force, that area of law was dealt with under the Electronic Communications Act, and the Electronic Communications Act had an opt-out methodology. So you could send people direct marketing emails, SMSs, etc., as long as you provided them with the opportunity to opt out. In terms of POPI, that's been turned around now, and POPI says you cannot send people direct marketing information unless they are an existing customer, and then at all times you have to give them the opportunity to opt out. So you can send information to existing customers, but you can't just freely come spam people, and you do have to have the opt-out option with all the communication that you send out.